and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
The co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so and zeros and ones.
We left off in court on trial day 4. We are joining in for trial day 5. The defense had made their motion to dismiss at the end of the day. The court had denied it. So we are coming back into day 5 after a weekend break for the lawyers and the jurors. And we are beginning the defense case in chief. The prosecution has rested. There were a few things I was surprised by. They didn't really call anyone to do digital forensics at all. They had the co-defendant, Juliana, the au pair, say, yes, these are the messages we sent. And yes, this is the account we set up, and did a lot of that foundation through her, but they didn't go through her phone. They didn't even bring in the defendant's phone. Like, where was the defendant? And I mean, maybe it's because they knew where the defendant was, and we've got a timeline based on the 911 calls and the video at McDonald's. But for a case that involves a fake account created to lure someone to the house, there was a surprising lack of digital forensics. And I worry because the prosecutor has been almost off-puttingly casual. And I'm trying not to be super critical, but this is where I start to feel like back in my day, which I hate, but also here we are. The prosecutor's interactions with the court have been quite casual, and it almost feels that the prosecution is maybe overconfident in the testimony of Juliana. Where my mind changed a little bit on that was with the victim's father's testimony. The victim's father's testimony was one of those moments in court where I was just like, wow. The victim had a medical condition and a blood disorder that caused her to bruise exceedingly easily, which probably answers some questions from the coroner's report, and to have a difficult time clotting and not having excessive bleeding. Something she had to take precautions about when pregnant and giving birth, something she had to take precautions of when little. And I think the key takeaway from me in that was when her father said she could not be involved in any contact sports. That was something that could cause harm to her, talked about a risk for internal bleeding being devastating for her. So when you look at where I think the defense is going to try to go with, well, no, the victim set up the liaison with Joseph Ryan. The things that were being asked for in those communications do not track with the things that we know about the victim. So I'm real interested to see how that's going to go. And perhaps it was truly the victim's father that is going to be the thing in this jury where all the jurors just look at this and go, there is no way this victim is doing the things that you want us to believe that she is doing. When the jury gets charged with this case, if there's 2 reasonable explanations, you have to pick the one that points towards not guilty. But is Christine Banfield setting up this encounter with Joseph Ryan a reasonable explanation? And the jury is going to have to ask themselves that. So today, we're getting into the defense case in chief because, oh boy.
Is anything bothering you right now?
I feel unsteady.
Okay. Were you hit with anything? A knife? Anything?
No, I took the knife. I took the knife from him.
Okay. All right.
How did you take the knife from him? I'm guessing after he was shot then.
So you're not hurt anywhere. Is that not your blood, correct?
I think it's.
All right. You want to slip this jacket off for me so we can evaluate you real quick? I'm going to have you kick your other foot up for me.
Yeah,
so you can
I think
get it on.
Yeah.
So just to confirm, nothing's bothering you right now, right? Physically, you weren't injured at all.
Anything hurt you at all, man?
It sounds like the defendant is starting to cry, not in court, in the body cam, which is probably why they wanted the jury to see it, to see that he had an emotional response.
Hi, sir. My name is Gina. I'm one of the doctors here. Your wife has died.
Well, that is the doctor's. Can we check on the status of his wife? Yes, sir, I'm one of the doctors here. Your wife has died. And then the doctor says, I'm so sorry at the very end of that. And defendant is back to wiping his face in court.
You were there at the time. So is there any part that I can help? I can explain what happened when she arrived here, but you were there and it sounds like there was a lot of blood loss.
Yes.
And so I think that she died of blood loss. Her airway was actually okay. I'll call the medical examiner, of course, and we'll do an autopsy and make sure we know for
Yes.
certain. But
I was trying to apply pressure.
yeah.
And I don't know if this is a different medical professional that he's having a conversation with, but you can hear him saying, I was starting to apply pressure, or I was trying to apply pressure, and saying, whoever the medical professional is speaking to him saying, I think she died of blood loss. Her airway was okay. They're going to do an autopsy.
I mean, those were enormous wounds, and it's not.
There were so many.
Yes, and the neck is not compressible, so it's not possible really to stop all the blood loss. And her airway, it seems like, was in the midline okay. She was able to be intubated. Everything that was possible to be done was done for her right away. You did a wonderful, you did everything that was possible. It's not a survivable injury.
And telling him, we were able to intubate her. We did everything we could. You did everything you could. There's nothing you could have done because of how catastrophic the injuries were.
Did the person come after you at all? Did they hit you or?
I'm curious what his answers are.
At one point, but
I think he put his arm on me at one point.
You want to wash your hands?
Oh. Interesting. The nurse said, you want to wash your hands.
When you entered the room, Mr. Banfield was on his knees next to Christine Banfield. Is that correct?
Yes.
Okay. But Mr. Banfield wasn't using that blue towel we see to staunch the bleeding from her neck. Is that correct?
Objection to leading, Judge.
It's cross-examination.
Cross-examination.
I do not believe he was, no.
Okay. And he wasn't using the nearby blankets, correct?
Correct.
Okay. And he wasn't using the sheet?
Correct.
Okay. Thank you. Nothing further.
Ma'am, you had an opportunity to listen to Ms. Graff yesterday, correct?
Yes.
And in listening to her
That's
testimony
fair.
yesterday, did you have any agreement
Ma'am, she's wrong, right? Can you tell us why she's wrong?
or disagreement with what she said about certain bloodstains?
There were certain bloodstains that I did not provide a classification for that she did.
Okay. And are there any in particular that you're speaking of?
Well, the forearm stains was one area. The 4 irregularly shaped stains that are on the forearm, she provided a classification for as being drip stains, and I did not.
Okay. And why did you not provide a classification?
Again, as I stated, the target surface here really distorted or what we were able to see to get that sort of well-formed circular stain that you would be looking for to be able to say that it's a drip stain from the exclusion of all other mechanisms. Because once you've classified it as a certain mechanism, you've excluded everything else. I didn't feel there was enough information here for me to do that. And this target surface, it would be inappropriate, I believe, to do that because the target surface was not ideal for being able to do that.
Well, we are at the lunch break of day 5 of the Banfield trial, the first few witnesses of the defendant's case. And I don't know if I would say I was optimistic that defense counsel would be prepared or more prepared for his witnesses than he was for the cross-examination of the codefendant. But whatever little hope I had is been thoroughly quashed at this point. And the first day of the defense case has been clunky at best. He brought in 2 law enforcement officers to show the entirety of their body cam footage, to include the body cam footage of the defendant in the ambulance and then at the hospital when he was told that his wife passed away, and interacting after that up until the time the detectives started to interact with him at the hospital. So the jury got to watch the entirety of that body cam and then a second body cam of another officer responding to the scene and then getting to the scene. And then the defense's first expert, their blood pattern stain expert, and they are hitting some of the same objections that the defense hit the prosecution with on what their expert can testify to and can't testify to. So far, we have gotten to the blood on victim Joseph Ryan's arm. This expert is saying that she would not have qualified those or categorized those or classified those. whatever one of those words she used, as drips because the surface of the arm is more dynamic because arms have hair, and the dynamic surface makes it hard or impossible to categorize the blood on the victim's arm as drops, meaning they were falling through the air as opposed to some other way, and disagrees with the prosecution expert analysis and classification of those items. And that's really about all we've gotten through with this expert. The defense also took some of the jury's time first thing in the morning to go through 80 exhibits and admit those into evidence. There were numerous prosecution objections. I think all but one of the prosecution objections to defense exhibits was sustained. Yes, that could have been done outside the presence of the jury. No, the defense did not choose to do it that way.
And sir, this is your personal digital forensics executive
He said
summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this is related
Yeah, he has not covered this officer's background, training, and experience. Nothing. You wrote this? Great, let's write it.
to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge,
Yeah.
at this point.
Reports don't go in. There's no foundation for it. There's no foundation for the conclusions in it. Reports are not evidence. His testimony can be. So I'm not surprised the Commonwealth's
This in
objecting.
as Defense Exhibit 85.
Any objection?
Yes, Judge, at this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is the objection, so sustain that objection if you want to leave.
I can do that.
Sure.
Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
Now, sir, is this report the report that you created?
Interesting.
Yes, I wrote this.
And when was this report created?
I don't recall the exact date.
Okay. That's all we can rely on is your memory. And Your Honor, I don't have any further questions.
All right. You have cross-examination.
My
I
goat
mean,
scream won't
Judge, I
even.
would note that. No, I have no questions at this time.
Okay. Now, can you see the document that's on your screen?
I see Detective Miller's executive summary.
Yes.
Yes,
Have you had an opportunity
Okay.
to do that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Okay. I'd move it into evidence. as
Objection,
Exhibit
Judge, it's a
85.
hearsay document at this time.
Oh, shit. Did he forget that he didn't move it into evidence when he excused Detective Miller from the witness stand? Because you can't publish it to the jury until it's admitted into evidence. And it was marked for evidence, but he didn't admit it. He took Miller off the stand. He qualified him as an expert, and then he was gone. Oh my God. We are at the afternoon recess of day 5. The defense has asked for a Hail Mary 10-minute recess to try to grasp with both hands the error that they have made in court this afternoon, because they called Detective Miller. They qualified Detective Miller as an expert. They asked Detective Miller about their report. They marked it for identification. They did not move it into evidence. And then they dismissed Detective Miller subject to recall, which shocked me how quickly the defense was just like, okay, we're done with this witness. They then called what seems to be their privately hired digital forensic expert, who's a former Fed. We got through lots of background and training. The prosecution did not object to the foundation for the raw data that was provided in discovery. And it would have been pretty shitty if they hadn't stipulated to that, because if they sent a subpoena to Discord telling the defense they have to bring in the Discord person when they subpoenaed it from Discord and it was turned over is inappropriate. The prosecution got it. They turned it over to the defense in discovery and they said, no, we have no problem with the raw data. We have foundation for that. And then the defense has started trying to get into their expert opinions evaluation. And their expert's evaluation was of the derivative data of Miller as to the devices. Anything with an on button, the computer, the phones, etc. And they have hit a tremendous roadblock, as the prosecution says, no foundation. And the defense is like, Detective Miller's report, and the prosecution's like, it's not in evidence. And the court's like, it's not in evidence. So the defense doesn't seem to understand what their expert evaluated and how, and how he made his reports. And oh boy, what a mess. Because now the jury is back out. Nothing has been learned other than how much the digital forensic examiner, A, loves what he does, which love to see it, is a talker, and evaluated the derivative reports from Detective Miller that aren't in evidence. Leonard, a quick moment to thank today's sponsor, Incogni, and to talk a little bit about my cats, Fred and George. While we know the pets can be mischievous, it's not as mischievous as this Petco data breach from December 2025. The information that came out about this Petco breach was wild. They indicated that the data that was exposed was names, date of birth, social security numbers, driver's licenses, and bank account numbers, as well as credit and debit info. But what do you do after your data gets out there? Well, that's where Incogni comes in. Not only is Incogni available risk-free for 30 days, meaning you can just try it out for 30 days and then get a full refund if you're not happy with the service, but Incogni makes it incredibly easy to go get your information back off of the web where data brokers are selling it. Incogni lets me just set it and forget it. And I know that they will let me know if they find new data out there, and they will be going out and taking that data back off the internet, because what is clear is that these breaches are going to continue to happen and your information is going to get exposed. But what you can do about it is make sure that you aren't leaving it out there for data brokers to use nefariously. So now's the time to take back your personal data with Incogni. Go to incogni.com/Emily and use code Emily to get 60% off annual plans. That's right, 60% off annual plans at incogni.com/Emily with code Emily. All right, let's get back to it.
All right, call Detective Miller.
Detective Miller? Okay.
I don't even know what witness number it is. We're recalling Miller?
What was your determination based on this particular executive summary?
That based on what I had at the time, it indicated that the device owner was using the device. The Gmail account that had been created on January 9th was the email account that was used in the creation of the FetLife account.
Okay. And were you able to determine through your expertise who had control of the device, Christine's devices on that day?
I was able to determine that it was her phone involved in creating that device. I was able to determine that it was her phone used in the creation of that account.
You can't determine who's using her phone, though.
Based on a variety of returns.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Her phone wasn't stolen. Her spouse was jumping on her phone when she wasn't around it, if we believe the story that's being told. She did not lose her phone. She did not lose dominion and control of her phone. Her spouse grabbed her phone per the other testimony, but no, it wasn't lost. It was still her phone.
As per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
A codefendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so any zeros and ones?
At the end of day 5, I don't know if I can tell you what the defense accomplished other than a full day of court without making much headway. The jury watched body cam footage that they hadn't seen before of the defendant reacting to being told that his wife had died at the hospital. They brought up a very chatty digital forensic examiner, but they hadn't admitted the documents that they needed for their digital forensic examiner to make their conclusions. And so they admitted his background and training and experience and him generally talking about digital forensics and talking about the fact that, digital forensics can't really put the person behind the screen. And then they were just starting to get into the evaluations that expert did and hit the roadblock that they hadn't established the foundation with Detective Miller, who was on the stand for 7 seconds and then was off the stand. And then The digital forensic examiner was off the stand with no questions and no cross-examination. And then Detective Miller was back on the stand. And Detective Miller was on the stand to testify that he did the digital forensic extractions of the devices, though we don't know what devices, because he never said what devices. He said of the devices, but he never specified which devices. He said that he wrote the executive summary with his conclusions. And from all the questioning, it sounds like when Detective Miller wrote his summary that he said that the device owner, Christine Banfield, was the one on her devices and was the one interacting with her devices, and that she was the one using her devices. Detective Miller said new evidence came to light. There was more context because Juliana said she was the one doing it. The device did what the device did, but I can't say that Christine Banfield was doing those things. And that was a very long, slow, painful slog to get to. In my report, I said it was Christine Banfield doing these things. And then I saw that there was more context. And then I changed my mind. And I can't say that it was Christine Banfield doing these things. It was Christine Banfield's phone. It was Christine Banfield's laptop. But I can't say she was the one using it. That's where we're at the end of day 5, is that it seems that the digital forensic expert that the defense called agreed that this was a catfishing case. That was my only takeaway from his testimony. And that Detective Miller seems to believe Juliana when she said she was the one using the devices. I imagine day 6 is going to be more of this, but I guess now I'm just going to wait and see when the defense is going to call back their expert, because at the end of day 5, I still don't think, unless they did it at sidebar, I still don't think that the defense admitted the report from Detective Miller, because we never heard him say that he's moving it into evidence. I will say, on a positive note, the defense attorney has consistently referred to Juliana's testimony as a recant or a story. That's been consistent. And we have not seen a case where a defendant has tried to argue heat of passion. And that will be something that will be new for us if the defendant takes the stand and tries to say this was heat of passion or self-defense, defense of others. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.